Well, welcome back to the continuation of the conference with transformation of the capital system trials. So we're here today to talk about the reduction in use at trial and the changes that we see across the trial landscape and the persistent issues that dog us as the death penalty is put into practice at the trial level. But I want to start with who our panel is today, because what we have is a group here that comes at this trial level issue from a variety of perspectives. So immediately on my left is Elizabeth Semmel, who has done capital work at the trial level, but also at the policy level as a director of the ABA Death Penalty Representation Project. She's now the director of the Death Penalty Clinic at UC Berkeley. She is the founding director of that program, and she's also a clinical professor of legal education there. So she's seen this system in a variety of different iterations. In the middle is Judge Tom Price, who was one of the longest serving, if not the longest serving elected judge in the state of Texas, was on the bench for more than 40 years, starting first in Dallas County in the courts at law, then going to the district bench, and then finally serving nearly 20 years at the Texas Court of Criminal Appeals. And it's too bad we don't have anybody from SCOTUS in the room, because what I want to say about Judge Price is 10 years before the Supreme Court recognized in Martinez versus Ryan the right to competent state habeas counsel, Judge Price sought to recognize that in a dissent in a case called Ex parte Graves concerning Anthony Graves, since determined to be innocent and no longer on death row. So you're going to hear some more about Judge Price's views and that set him apart in some ways from the Court of Criminal Appeals. Finally, on the end is Dana Lynn Reeser. Not only is she a graduate of the University of Texas School of Law, she's a Longhorn through and through, having gotten all of her degrees here, and came to the death penalty movement, or the representation place, actually as a PhD student here, investigating the use of lynching. And so she gets drawn into the capital defense world, goes to law school, and then goes to the killing fields of Louisiana and works there with the legendary Clive Stafford Smith. And has a reputation for being able to get life sentences at trial in a place where that's very difficult. Then when Calvin Burdine, who's the victim of the sleeping lawyer Joe Cannon, gets a new trial in Houston, Dana Lynn comes back to Texas, takes that case on pro bono, and after getting him a life sentence, negotiating for that, she founds the Gulf Region Advocacy Center and has not only practiced then capital trial work in Louisiana and Texas, but now is doing so in the federal courts. So she brings also a national perspective to what's going on in our capital system. Now, somewhere along the way, I know that I had the clicker for this thing. Here it is. And so I want to make, in this season of campaigns, some promises today, all right? So the promises are, this is live, it's unscripted, and it's going to be huge, all right? And, well, maybe not that huge. But anyway, what we're going to do here today is we're going to touch on topics that have to do with the trial of cases that we've seen in our experiences, in our differing perspectives, not me, them. And what I would like to do, particularly at the end, is to have questions from you all. But if there's something that's really like a burning issue you really want to ask about, raise your hand and let's get a discussion going. Because what's happening at the trial level really is transformative. And it's something that we can't overlook. So, you know, one thing I want to just point out, you know, in Texas, which, okay, we're the biggest user, right, of the death penalty. I mean, California's got a bigger death row, but we're more robust in putting people on death row and then executing them. Last year, we only have 2 new death sentences. We have a jury that delivers a 3rd death sentence, but it doesn't become final until January of this year. And so that goes from a high of 48 in 1999 down to 2 last year. That's pretty amazing. But it's not just the reduction in new death sentences that we see in Texas. What we're also seeing is a reduction in the likelihood that a jury is going to sentence a defendant to death. And this is something that, as I go out and teach around the country, I think we're seeing in a lot of different places. California and Kentucky, for example, 50% or less chance of getting a death sentence at trial. In Texas, we've fallen from over 80% down to an average of 66% over the last 10 years. I mean, last year we were well below 50% in the prosecution's ability to get a death sentence at trial. So that tells us something about the tethering of jurors to the death penalty. And so this is our jumping off point. And it's this quote from Judge Tom Price in a case very close to my heart, ex parte Panetti, where dissenting from a decision to deny a stay of execution, Judge Price says, "I believe that this decline in the use of the death penalty is because district attorneys and juries now have the life without parole option and are less convinced of the absolute accuracy of the criminal justice system." So Judge Price, let's start with you and tell us about how you came to these conclusions, that you believe that district attorneys and juries are less tethered to using the death penalty.
Well, I sort of grew up, actually I did grow up being a judge. I got out of law school in 70 and I was elected in 74. So I've become a different person probably every other year based upon my experiences. But now we have fewer and fewer cases that are picked by the prosecutors throughout the state in deciding what cases should be tried for death. I think a lot of that, and the last case that I tried as a trial court judge was a death penalty case that took over 5 months to pick the jury. The hesitancy of the prospective jurors was, back then you couldn't talk about parole. So jurors were hesitant even back then, which was over 20 years ago when I tried this case, and the defendant is still on, the accused is still on death row. I haven't been able to find out why, because I haven't been able to hear the case. But back then, the biggest hesitancy of the hundreds and hundreds of jurors that we went through in trying to pick a jury in Joseph Lave's case was their hesitancy didn't want to give the death penalty, but really didn't want to be in a position that this person would ever get out of jail. So in this case, the state was saying, if we can't prove to you that this accused was actually one of the ones that cut the boys' throats in this case, could you consider the death penalty? And the jurors were saying, no, no, no. They couldn't unless you could actually prove that there was some connection in the actual physical act of cutting their throats. That, as a trial judge and as a district judge, you hear so many horrible fact situations. My personal feeling back then was the death penalty was a good sentence. As time has gone on, jurors have changed their minds, prosecutors have changed their minds, and I've evolved. My feelings have gone back and forth. As a politician judge in Texas, you're required to talk about what you feel, and for a candidate to get up and say I'm against the death penalty would probably be a sure shot that you're not going to get elected in Texas. So you become a politician. I have changed, and being on the Court of Criminal Appeals has allowed me to broaden the way I think, and I've watched the number of cases that have come before the court, fewer and fewer cases. And I think the hesitancy that these jurors had 20 years ago is also gone into the whole system. I think prosecutors are less anxious to seek the death case except in the most horrible fact situations. Jurors now know that they can give life without parole, and that option is being used more and more. And that was their problem back 22 years ago when I tried Lade. They just didn't want him to get out. And that's sort of been fixed now with the life without parole. They're able to now be told that he will never, ever, ever get out, and that satisfies people. I think they were not all, people are hesitant, have been forever to assess the death penalty. And you stay on death row for so long, I found that victims, the families of the deceased, like the fact that they know the outcome. He's never, ever going to get out. They don't have to go through these endless appeals and endless decisions. So I think all those combined, and with my own feelings, I didn't want to come out and say I'm against the death penalty while I was on the court, because I would expect motions to recuse on every death case that came before the court because of my feelings. So I sort of laid back. I even got accused when I came out with my decision in Panetti of being a chicken, that I should have had this decision way before I did at the end of my career. But that would have excluded me from being involved in death penalty cases because I think the court would agree that I should be recused if I didn't believe in the death penalty enforcing one of the laws. So I've changed, prosecutors have changed, and jurors are now satisfied that when they give life without parole, they will never, ever, ever be released.
Well, and that allows me to ask Dana Lynn, do you see any change in defense counsel as you go out and do your work at the trial level? Because the judges talked about judges and prosecutors. So can you talk a little bit about defense counsel here?
About defense counsel?
Well, I'm going to ask Dana Lynn since she's working with them more directly. So can we?
Oh, you
Yeah.
Yeah, I think that there's been a big change in defense counsel in the standard of care, of course, with the ABA guidelines, but also in understanding that the cases are not impossible. I think that used to be, we thought that it was impossible, and the sort of conventional wisdom was it was impossible to win if you got to trial, and so so the goal is obviously to settle these cases, and it still is. But I think that there's been enough success and enough the impact of reversals, and that defense lawyers are now sort of a little bit more optimistic. But what we've also seen, I think, is that not only due to the LWOP and due to the concerns about innocence and error rates, but also because defense lawyers are seeing the failure rate of the death penalty and the effect that it has on prosecutors and judges. I think that if you look overall at the data, and I think Sam Gross is here and the work he's done and Jim Liebman on just the failure rate of the death penalty, prosecutions have not been that successful if you look over time. So I think that one of the changes I'm seeing in defense lawyers is recognizing that they can litigate pretrial motions, that they can do more investigation, that they can fulfill the ABA guidelines and work with the tools that they have to pursue these cases in a way that will be heard by prosecutors and judges differently than it used to be. I think that in some ways the arbitrariness of the death penalty, the fact that that judges and prosecutors have felt sometimes that the case law changes in a gotcha kind of way. We see that, statutes, Gregg, of course, the statute is approved, and then along comes Godfrey and Coker, and there's constant tweaks, and I think that courts are recognizing that they weren't given all the particulars. The Supreme Court rulings all the reinstatement cases are so contradictory internally and so impossible to fulfill that they don't give you particulars. They leave it to the trial courts and the legislatures. And that is a huge opportunity for defense lawyers that we're beginning to recognize and use. And I don't think people really understood before. To my mind, the question is really not why are we now seeing a change and now seeing the numbers go down and seeing the system sort of collapse in on itself. It's really why did it take so long? Yeah. Because the whole thing is self-contradictory, as we just heard from the last panel, from the very beginning. And I think that defense lawyers are learning how to make use of that. And I think that prosecutors and judges are taking it more seriously because there have been so many reversals. And there have been so many what they feel of as sort of gotcha moments that, you know, now they're listening.
Well, you know, Liz, you're one of these people who's training defense lawyers. In fact, I see even one of them in this room that I know you trained. And you also were there when the ABA began the effort to revise the ABA guidelines in death penalty representation. So, you know, could you talk a little bit about the ABA guidelines and where you feel like they've been effective, but perhaps maybe where we need to go with them, particularly as it affects the trial level?
Well, you know, it's interesting because accidents make history or something like that, or maybe history is too big a word. But when I joined or became the director of the ABA Death Penalty Representation Project in '97, it really was my first encounter with the guidelines because I was trying capital cases in California. The guidelines were just not particularly on my radar screen. When I got to the project, I was being asked oftentimes by lawyers in states like Texas, Mississippi, Alabama, Louisiana, for declarations about what do the guidelines require me to do. So, you know, a lawyer would say, I can't get resources to hire a pathologist, I can't get second counsel, et cetera, et cetera. So I got pretty adept at, you know, drafting affidavits or declarations that they would then file to try to persuade a trial judge particularly to provide whatever meager resources the trial judge was willing to provide to make some passing effort to comply with the guidelines. But in the course of doing that, I became very concerned that the 89 guidelines simply were not in sync with the standard of practice. I mean, because the good news is we all get better, we all do better, we all learn, and the guidelines had not kept up with best practices. The core, you know, of what they stand for and the message they were conveying about quality, vigorous representation was there. So I started a project with some of my students at Georgetown to take a serious look at what would we do if we could persuade the ABA to undertake a serious revision. That was the genesis of it. And obviously, by 2003, we had a whole new set of guidelines. And what I will say, and I say this mostly from my experience teaching at places like the Brian Scheckmeister Death Penalty College, where, you know, every year you see 40 capital trial lawyers come with their cases, or at other programs, the prominence of the guidelines in teaching lawyers what they absolutely must do in order to be competent, you know, not to mention effective and vigorous and relentless. I mean, they are a constant at every meeting, at every training session, at every conference. And then I think, and I want to add to this because I think this is important, you know, you get a lot of lawyers coming to sessions like this who, you know, you can put all the PowerPoints up you want, you can provide sample motions, et cetera. The question is, what are they going to do about it? So I think, you know, the guidelines are critically important because if nothing else, they empower lawyers who want to do well, who want to be that kind of advocate. They empower those lawyers. But the question is, how do they force institutions to change? Because the guidelines are not just about this is what lawyers have to do. They're critically, you know, centered on the fact that judicial appointments in capital cases are responsible for, I'll just put it very bluntly, a lot of very bad lawyering, about hundreds and hundreds of cases of bad lawyering. And, you know, systems that tolerate $40 an hour out of court, $60 an hour in court, or a $1,000 flat fee. So the guidelines are important in terms of institutional change as well. And that's, I think, where certainly the ABA has tried to effectuate that institutional change by going state to state, but I think it's been tougher. And so the point I was actually getting to, and then I'll wrap up with this comment, is the trial consulting projects that exist, the Texas Defender Service, the Project ACRE in Pennsylvania, Steve Harbor's project in Florida, the Mexican Capital Legal Assistance Project. I think it's a mistake to undervalue the extent to which those projects, which match experienced capital lawyers with often unwilling or unskilled or underqualified lawyers, really cannot be overstated. Let me make one last comment, because I think it's important. You know, we talk about these cases that came into the courts, and I'm still working on some of them that were tried in the 80s and tried in the 90s, you know, with lawyers who did not present any evidence in mitigation. But I think it's important to remember that those kinds of cases are still being tried today by those kinds of lawyers. And so in the last week or two, a case, Horton versus Alabama, involving a defendant in Alabama, was just reversed by the Alabama Supreme Court. It was a case that EJI had. Now, this is a 2010 death penalty case. And it involved a lawyer who, the mass of the prosecution's evidence in this case, because the facts to prove guilt were, as we might say, not overwhelming. So instead, the prosecution loaded in tons of collateral criminal evidence, you know, other bad acts the defendant had done to show that he was a bad person, therefore he committed this crime. And, you know, this is a lawyer who filed a perfunctory motion in limine to preclude this evidence from coming in, then never objected to it when it came in at trial. And we're talking dozens of prior bad acts. Never objected, and never objected to other kinds of highly prejudicial evidence. This is kind of lawyering 101. Fortunately, the Alabama Supreme Court reversed, but the point is this is lawyering that was going on in 2010. So I think we have to, what I guess I would say is we have tools because of the guidelines, because of some of the wonderful work the ABA has done, consulting projects, and I would say importantly, state capital defender offices, we are better positioned to make a difference at the trial level, and that accounts for significantly for the decrease in death sentences, but we shouldn't delude ourselves into thinking that this is that the problem of ineffective assistance of counsel has been solved.
Well, I think a lot of that, though, is because I've been a trial judge most of my life, it appears. Judges will sometimes appoint lawyers not based upon how good they are, but how they're going to make their life easier during a trial. So you're not getting the best lawyer appointed. You're getting a lawyer that offends the judge the least. And I think when you do that, the representation that people get that are charged with capital cases is deficient. And as long as, at least in Texas, when you allow judges to appoint their buddies, to appoint people that are not going to irritate them during a long trial, just like in the case where it took 5 months to pick a jury. If I'd have picked, and back then, I did my best to pick good lawyers, but I think a lot of judges didn't. Who is the lawyer that's not going to get me reversed? Who's the one that's not going to upset me during a long trial? And they're not looking for who's going to do the best job. They don't want to try it over again. If you don't have a good lawyer, you're probably not going to get reversed. The best lawyers don't want to try death cases. Can't afford to try them. Can't afford to be in a courtroom for a month or two at a time. So the system is pretty much set up for failure in a lot of ways because of how lawyers are appointed and the competency of those lawyers.
Well, now, Dana Lynn, you've worked in both I mean, I know you're now in the federal system, you know, as learned counsel, but you've worked in a state system with a with a pretty robust defender system. You've worked over here in Texas where there's the regional public defender for capital cases, but which does not cover any of the urban counties that are responsible for loading death row with its inmates here. So can you talk a little bit about what some fixes might be to this problem that Judge Price has identified of judges appointing people as defense counsel who aren't going to impede the train on its way to the death station?
I think we do see that, and in the work that I've done, you know, we do these bring your own case trainings, these intensive consultations around the country. There's several projects that do that, and we've gone into virtually every capital jurisdiction in the country with those, and other consulting projects. And what I see is that I think that there really is a national standard in the positive sense that Liz was talking about in terms of the ABA guidelines and people finally sort of getting the memo of some of the things they need to do. But there's also a national standard of sort of mediocrity. Like, we see the same problems everywhere. And one of the things that I routinely say in these sort of trainings is that folks always believe their jurisdiction is the worst. Wherever we go, they say, well, I don't know how things work where you are, but where we are, this is how it works. Everybody thinks their county or state is sort of a unique little version of hell. And they're sort of right, but what we're seeing, I think, is that, you know, we see the same sort of problems over and over in terms of how to use the funds, in terms of how to be thorough and to understand what wins. I mean, one problem is that the cases that you read about, the cases that become case law, are all cases that lost. We don't have that much data about what wins. I mean, the Capital Jury Project has given us a lot of great data, but in terms of the lawyer's practice of things that don't make it into the courtroom, or more importantly, cases that don't make it in the courtroom, how do we stop cases? There's less data about that. But I have a trouble with the question about sort of what system. I definitely think we need to have independent appointing. You know, that having the judges appoint is a problem, not only because they want to make their docket move smoothly and they are concerned about cost and they don't want to get reversed, and they want a lawyer that will put up just enough of a fight but not too much of a fight. But even when it's in an independent system or statewide offices like I've worked with in Louisiana and Oklahoma and Mississippi, what happens is there's still the political sort of component because the groups get their money from the legislature, the heads of the groups are appointed. There's still a concern about sort of not pissing off the judges or not pissing off the prosecutors. When you have a centralized group, you've got a different kind of conflict of interest in the sense that you have all these clients you're responsible for, and so there's a concern about, well, if we piss off the prosecutor on this case, then we're going to have trouble with this case. So those sorts of, I think, practical concerns and conflicts and pressures happen in every kind of system. I don't know of a system that is immune to them. I think they come up in different ways. It's most explicit when the judges are both in charge of appointing the lawyer and in charge of funding. I think in Texas has been a particular problem because we've not had a public defender system for so long that most defense lawyers, never mind capital defense, but most criminal defense lawyers are solo practitioners who are utterly dependent on appointments in their jurisdiction for all of their work. And so they're really, creatures of that courthouse and dependent upon the judges, sort of as a group and their reputation for being able to move cases and not cause trouble and so forth. And so I think it's a particular problem there. But, we've seen similar sorts of issues come up in all kinds of settings. They come up in the federal system. I sort of balk at the idea that there's such a higher quality of work going on in the federal system. I think there's more money, but it doesn't necessarily mean that the right lawyers are appointed or that the money's used well. I think that, the training has to be sort of constant because we have the same problems coming up everywhere we go, things that people have been saying for years and years about how you do mitigation, how you bring in mental health experts, the do's and the don'ts, the pretrial litigation you need to be doing, getting pretrial hearings on your, the heightened reliability of the aggravating evidence and so forth. People still aren't doing, and we've encountered those sort of same problems really everywhere we go. Money, no money, centralized or, or judge by judge.
Well, you know, Liz, it seems to me, based on what we're hearing about the prevalence of problems, as you know, Judge Price has talked about it with judges wanting to appoint these go-along lawyers in some cases, and about Dana Lynn saying, hey, these problems are all over the place. It feels like indigent capital defense is like, it's not like planting a wheat field and coming back 6 months later. It's like milking the cows every day. But here you are. You're training lawyers to do this work. So what do you tell them about these challenges that aren't going to be taken care of, unfortunately, by the time they come out and practice?
Well, the truth is that I am not a believer in having my students go from law school, even having done the capital, you know, the death penalty clinic for a year, into the practice of death penalty defense. I mean, you know, that's my bias. My bias is you get out there, become a public defender, learn the fundamentals of how to try a case, how to settle a case, work your way up from felonies to misdemeanors, and then do capital cases. I just, you know, it's maybe that's too personal. That was my, you know, my upbringing. That's how I was raised. I just think that, you know, you're not prepared for this work. I mean, there is a reason why we have the guidelines that we do, right? There's a reason why, independent of the qualitative issue, which is grossly undervalued, in other words, the qualitative assessment of a lawyer's capacity to represent a client as to whether he or she should be appointed. Independent of that, years of experience count for something, years of trial work count for something. So I will just say that while I'm not a fan of that approach, I nonetheless managed to graduate any number of students, and I admire and respect them who go to the Southern Center or go to the Equal Justice Initiative. And the truth of the matter is that they're needed there. And the truth of the matter is they're better prepared to go there if they've done the clinic at UT or done the clinic at Cornell or done the clinic at Berkeley. But, you know, fundamentally, when you're sitting and reading a record by some lawyer who, you know, for example, the lawyer in Horton who failed to object to the introduction of the collateral evidence, and you've never tried a case, but you took the clinic, you might appreciate and understand the seriousness of the evidentiary and constitutional issue, but you might not. So I would make that comment. I mean, I'm just such a true believer in the way in which lawyers have to come up and develop skills. And, you know, even when you take your first capital case, I certainly didn't feel, you never feel quite ready. I did want to add an observation about public defender offices and the change. You know, John Bloom and Linda Van did a recent look, speaking of 40 years of Gregg, did a recent look at South Carolina 40 years after Gregg. And one of the things that they, in their view, from the empirical work they did, has made a significant difference in the decrease in death sentences is the fact that there's now a South Carolina Commission on Indigent Defense and a special capital defender office. So I agree with Dana Lynn, having been a public defender, those institutions have their own set of problems. But when we look at most states that don't have statewide defenders, and California is one with 58 counties and 58 systems of defense, you know, the kind of inequities, the gross kind of inequities that flourish county to county depending on the politics of the county, the fisc of the county, I think are in some ways ameliorated by statewide systems that can look at how to platoon resources in jurisdictions or in counties or circuits, for example, where there's absolutely no will to ensure the defense of indigent folks.
But how do you work? You're working with lawyers. Who's working with the judges?
The question was, yeah, they're working with lawyers. Who's working with the judges? Does anybody want to answer that?
I mean, I'm hearing what you're doing with lawyers, but part of the problem are judges, and I probably was part of the problem at one time also, because you just get into you're dug in, and you're helping the lawyers, but what are you doing with that judge who's still has the same bad habits he's always had?
You know, I think that part of it is on the trial lawyers to educate the judges, because, you know, the capital law moves so quickly. it changes so quickly that, you know, and judges are not just presiding over capital cases, they're presiding, and in Texas they might even have civil as well as a criminal docket, and depends on the jurisdiction, they may handle misdemeanors and felonies, they may handle all kinds of things. They're not just sitting there, you know, hitting refresh on SCOTUS blog. They're not up to speed no matter who they are. So we're always having to educate them, and I think that that makes it harder when you're appointed by the judge. It makes it a difficult dynamic, but that it really is on the lawyers to go in and to realize that you can't just accept what's handed to you. This is how things work, because the people that you're dealing with don't know, even if they think they know. The judges, the county funder, you know, the funders at the county or the state level are not up to speed on necessarily on the case law, not up to speed on the practices. And I think that most judges are really not up to speed at all on what the work takes. You know, the level of detail that's involved in mitigation work, understanding how resistant that many of the clients are, that it takes time. You know, we have this sort of myth that prosecutors put out that clients want to be found crazy or want to say their abuse, excuse, or whatever. It's entirely the opposite. Most clients are incredibly resistant. It takes a long time and a lot of finesse to working, and a lot of skill working with clients and their families. And so for judges just to understand the amount of time and understand that if they want to not get reversed, the best way to not get reversed is for the case not to happen, and the best way for that to happen is give the defense lawyer time to get their legs under them and begin to, you know, work up the case to get death off the table.
So is that part of your of what you're teaching in seminars, is for the lawyers to learn how to talk to judges?
Well, absolutely, and to litigate a lot of pretrial motions. And, you know, one of the things we talk about is to always come back to these constitutional issues, to Gregg. You know, what I see as a big problem with the way that some lawyers and some systemic ways of handling cases have interpolated and taken on the case law and the ABA guidelines is they come up with sort of standard packets and boilerplate things, and they're filing them not because they really understand or they're engaged with the issues, but because their boss told them or they went to some conference and they gave them a disc. And so they sort of know, okay, there's rules, I have to do this stuff, and they do it, but they're not really engaged with the why. And one of the things we're trying to teach folks is that you have to always stay focused on this completely irrational, fictional system that was just described by the last panel. You know, that we're going to have discretion, but you can't have impermissible discretion. You know, we're going to try to take race out of the death penalty. We're going to try to, you know, harness these, you know, primal passions in some objective way. It's an impossible and ridiculous errand that we've been sent on. If you understand that, then you're always coming back to that in litigating. What happens, I think, where the wheels come off the bus is when lawyers sort of accept the micro, and so they file all their so-called constitutional motions, but then they're litigating discovery and evidence and everything else in the same old way, and they're not touching back. So if you're not going to let me have this discovery, then that means we're not getting heightened reliability and we're not having these promises. You know, the only way that the trial judges are denying those so-called constitutional motions, the motions to strike, the dispositive motions, the only way logically you can deny them is by saying, we are going to be able to create safeguards. In this case, those problems won't happen. Yes, I see the error rates, but that doesn't make it unconstitutionally risky, because I can institute safeguards in my courtroom. Yes, I see the race and the disparity and the arbitrariness, but we're going to have safeguards in this case. And usually the state will argue that. The government will stand up against those motions and say, well, the death penalty isn't per se unconstitutional, but it's also not per se constitutional, right? They'll say that deny these motions because because it is constitutional, and deny these motions because we can prevent these problems from happening. These problems happen elsewhere, race, et cetera. I trust you, Your Honor, that you're not going to let that happen in this courtroom. And then for the rest of the pretrial, that's forgotten, and we focus on sort of the minutia of sort of state law and rules about discovery, about evidence, and nobody ever harkens back to say, wait a minute, what were those safeguards? We look at them each individually. You know, we look at one thing and it's denied because, well, we don't need to have suspenders because we've got a belt. And then we look at the belt and say, well, it doesn't matter, the belt's broken, we got the suspenders. Well, if they're both broken, then the promise that we've been given is falling apart. And that's where we end up with what prosecutors think are these gotcha moments where something that's been accepted for years and years is suddenly reversed and unconstitutional because the outcomes build up to where finally the court says, you know, we're gonna change this practice. So lawyers need to always be litigating in that sort of Gregg constitutional matrix, bringing everything back to that, and kind of with a faith of knowing that the whole thing will collapse in on itself if you hold people to their promises.
Okay, I want to turn now from this discussion to an area that I think really does involve perhaps some judicial education, maybe, and maybe even some lawyer education. And I want to go to Jurek. So in Jurek, one of the questions for the court was the issues was the impossibility of predicting future danger, which is a feature of the Texas death penalty statute. For a person to be eligible for the death penalty after they're found guilty of capital murder, they must then be found to be a future danger before the jury can consider the life or death question. And in Jurek, the point is made, it's impossible to predict this future violence with any accuracy. And for jurors, it's just going to yield more arbitrariness. And in fact, you know, the court says, well, it's of course not easy to predict future behavior. The fact that such a determination is difficult, however, does not mean that it cannot be made. Now, this is a great expression of faith, and yet we find out, you know, from publications as this by Mark Cunningham, that juror predictions of future violence are no better than random guesses. This is by a psychologist who's gone back and compared these predictions of future violence with actual behavior on death row in Texas. And then we have my own organization in 2004 looking at expert predictions of future danger and finding out that 95% of the time when the experts come into court and say, this guy's going to be a danger in the future, they were wrong. So this is one of the features of the Texas death penalty statute that the court didn't find to be a reason to overturn it in Jurek. What do we do about this on the trial level, Liz?
Well, I am not the person to ask about Texas. Fortunately, I've done one Texas
but
retrial
Oregon
case.
and the federal government also have features of future danger in
well,
their statutes.
I will say, I think we have to give a shout out to Rob Owen and to Jordan and, you know, to talk about Tenard, because I think we, without in any way and for an instant, underestimating the pernicious power of future dangerousness. I mean, thank goodness, maybe, the Texas courts understand how to instruct on mitigating evidence, how to insist that there doesn't have to be a nexus between the crime and the mitigating evidence. I mean, those are, I think, very, very significant decisions, which, oh, by the way, in Alabama, where I do much of my work, that message is yet to get home to Alabama. It recently, you know, came home to roost in the Ninth Circuit in a case out of Arizona, an Arizona case. So I just want to, I think that has been a help. Others are in a better position to judge than I feel sort of I wasn't expecting that question to come to me first, because it's, you know, it's an absolutely intractable, insoluble, insane. I mean, the panel before was talking about the foolishness, for lack of a better word, of prognostication when it comes to the U.S. Supreme Court. And I think everything that social science literature tells us and psychosocial science literature tells us that it's absolutely a fool's errand to engage in predictions about future behavior and to ask, just to frame this as directly as possible, but to ask jurors who are filled with anger and frustration about the person who they've just convicted of what they think and feels to them like the most horrible crime in the world, to make a judgment about what that individual will do in the future is, you know, it seems to me the answer is a foregone conclusion. Obviously, it has not been in every case because of fabulous lawyering, but in theory, at least, it's a foregone conclusion.
Judge Price, why haven't we seen the Court of Criminal Appeals take up the fact that the future danger question appears not to be probative of anything based on the social science research.
Well, you know, my court seems to be waiting for someone else to guide them rather than stepping forward themselves. So it's frustrating to work on a 9-person court when you have problems with certain judges that won't allow you to bring up issues and solve. They'd rather keep it like it is, to simplify it and wait for someone else to tell them that it's wrong. And it's frustrating. Going from trial court to appellate court is so frustrating to have 8 people working with you that just don't understand. There's no matter how much I talk to them, they just don't seem to understand. And it's one of the most frustrating parts of this job. But to answer your question, I think they're waiting for someone else to guide them.
Do you have a name for us?
I've got a lot of names for it,
Okay.
but I'm not going to talk about it.
Well, Dana Lynn, you know, you've litigated the future danger issue, and you know, it should be noted, you know, Dana Lynn convinced a Harris County jury to return a life sentence in the case of a man who had killed a Houston police officer, which in Harris County is pretty much a death sentence in most every other case where Dana Lynn Reeser isn't representing you. So and there was a lot of litigation around the future danger question in that case. So can you talk a little bit about that and where you think that defense teams might go as they grapple with this issue?
Yeah, I think that it's sort of an example of what I was saying earlier, that you know, you file these motions saying that this has got to be unconstitutional, which it clearly must be, because we have one of our 8th Amendment principles in the reinstatement package is that you can't have an aggravator that's true in every murder case, right? It's one of our principles. Well, then you're going to have future dangerousness where you take into consideration prison conditions and things that are true for every murder in the jurisdiction, or you have antisocial personality, which is going to take into consideration factors that are true for everybody who's committed murder. So we're bringing those things in, and so you know that it's sort of breaking one of those promises, right? And so you know there's got to be a way to demonstrate that. The court's going to deny your motion to strike and deny your motion to say that it's unconstitutional, but in denying it, then they're going to say, and the prosecutor's going to say, we can avoid these problems, also the risk, unconstitutional risk. We can avoid these problems by putting in safeguards. And that's your opening to say, okay, we're going to have pretrial hearings. And we're going to have pretrial hearings to test the heightened reliability of this evidence. Because if you take the 8th Amendment jurisprudence as a whole, it's telling you that you have to test this evidence and that we're concerned with an outcome, not just a process. And if the court denies your motion that it's unconstitutional, then they must think they have a way of doing it. So we're going to have pretrial process to do it. And then we have Daubert hearings, but we also, I think, get heightened reliability hearings on all of the aggravating evidence from the prison guards and everything else, and put it all on. And when you do that, it does start to fall apart. You do get little bits of it excluded, and I think that's one of the problems with some trial lawyers. Is not sort of understanding that you're not looking for slam dunks. You know, you're going to file motions that on their face are going to be denied, but they're going to be denied with a process that comes along with it, and that you're going to get things knocked out. So we've litigated in Quintero and other cases, litigated, for instance, the prison evidence you put on those folks, and some of what they have to say in their reports and so forth, some of it's hearsay, some of it gets excluded for that reason, some of it is they're reporting protected activities of the client in terms of nasty language that they used or beliefs that they expressed, and you nibble away at it. You get little bits and pieces of it excluded because we don't kill people just for being assholes, right? And a lot of that evidence, that's all it is evidence that the guy's a jerk. It's not evidence that he's a future danger. So you whittle it away before you get in front of the jury. You also, with the experts, in Quintero, we were able to keep all the experts out, and the way that happened was in a Daubert hearing, when they put up their experts, just demonstrating that what they're relying upon is all evidence that's not about the client. So again, getting away from the evidentiary rules and the kinds of things that people normally look at in their Daubert hearings or their pretrial hearings, and sticking with those constitutional principles and saying, well, that's not individualized sentencing then if you're relying upon you know, predictions of the number of prisoners that commit murder in maximum security, or if you're on level G, you know, your access to do this and that. That's not individualized, and so it goes out, and the expert can't depend on it. And you start stripping that away, what they have left to depend on is basically just their bias that anybody who ends up in the seat that your client's in must be dangerous. And that sort of tautology kind of, you know, that's Robertson versus Louisiana. You can't do that. You can't have mandatory death penalty. So, so what happens in those hearings then is you don't get a win, you don't get a ruling on the record, you don't get something published that you can use. You get sort of negotiations, and then the prosecutor and I huddled, and we both decided, okay, I won't put on my experts if you don't put on yours. And it just sort of goes away because you've illustrated, again, that upon examination, they can't fulfill all the promises they've made to your client. So, or that the Constitution has purportedly made to your client. So you do it just incrementally. But there's no silver bullet. You're not going to get, you know, stamp granted on your motions almost ever. But you create just enough space that you can nibble away at things and just illustrate what's wrong with them.
I wanted to put an exclamation point on what Dana Lynn was saying about aggressive lawyering in terms of motion practice. Because I think I was involved in a case in Solano County last year in which it was a public defender case. The lawyers represented a young African-American man accused of killing a white police officer. Solano County is close to San Francisco geographically, but not politically. The county is 15% African-American, which is actually a very unusually high percentage of African-Americans for a California county. And so you can see the dynamics of that case. And the lawyers in that case raised a venue challenge, they raised a jury composition challenge, and the one that I worked on was the challenge to death qualification. And obviously everybody went in wanting the slam dunk. I mean, we wanted no death qualification, we wanted change of venue, et cetera, et cetera. And of course, you know, as Dana Lynn pointed out, that wasn't gonna happen. But what did happen in the course of putting those motions on, and it was the triumvirate, for lack of a better word, of these very, very robust motions and putting the evidence on, is it completely changed how that case was tried from death qualification to general voir dire and the exercise of peremptory challenges. And instead of a likely jury in that county of, you know, maybe 1 or 2 African Americans on the jury, there were 6. And the case mistried in penalty and ended up with a life verdict. But there is no question that it was the lawyering, it was the insistence on the assertion of constitutional rights and tying them back to the promises, as Dana Lynn was saying, that made the difference in that case.
Well, and this allows us to segue into the issue of race in the courtroom. We've heard from the prior panel, it's a persistent problem in the administration of the death penalty. And of course, those of you who don't know this statistic should, that since October 2004, Harris County, Texas has not sent any new people to death row who aren't people of color. And so these are their pictures. And in fact, 3 of them are now off the row, one of them by suicide, which is not good. But one of them who's now off the row is innocent. So we have this problem, certainly in Harris County. Let's see, there's the other problem that we have with Texas overall is that people who kill white victims overwhelmingly are represented on death row. Among those who have been executed, you know, African Americans have been executed wildly out of proportion with their representation in the Texas population. But I think that, you know, let's go back to this issue of race, which pervades the system. I mean, for example, Harris County has had decades of problems with Batson, what we now call Batson violations. At Dallas County, which in the Miller L case was litigated by faculty members, people who are now on faculty here at UT, chiefly Jim Marcus, and with other help, and certainly with Liz doing an amicus brief in that case. So let's start with you, Liz, and then Dana Lynn, can we go to that? Because I know that you also litigated Batson issues in Quintero.
So the thing I want to start by saying is that I believe it's time to take on death qualification again. And we did this challenge in Solano County. We're going to do another one there. I could go into a long exposition about why, and I'm happy to, but I want to take up too much air. But I think that from the point of view of what data we have, what the research tells us, which is different and better than what happened in Lockhart in '86 when people thought the door closed to death qualification, I think we're in a different era. And I think particularly, and this was the theme in the Solano County case, when the difference between the views of African Americans on capital punishment and whites on capital punishment is as enormous as it is, the argument that death qualification will essentially strip the jury of African American jurors creates, it creates potential, I think, in the 6th and 8th and 14th Amendment that was not there or couldn't have been realized at the time of Lockhart. So that's a quick point. But the point about Batson is equally important, because what happens when jurors are death qualified is, of course, their souls are laid bare in terms of their views on the death penalty. And those people of color, particularly African Americans, considering this disproportionate number who oppose, who are not excused for cause during death qualification, are then in the panel for general voir dire. And what happens because of peremptory challenges is that prosecutors will strike, and when they strike, their race-neutral reason, which has been sanctioned by court after court after court, the race-neutral reason is that the juror was unfavorable on the death penalty. So prosecutors get a free pass because of the really sort of ugly symbiotic relationship between death qualification and peremptory strikes. And so I think that when we talk about challenging, we have to think about the two. In a capital case, we have to think about both together.
Dana Lynn.
I agree with that, and I think that you asked about the Batson litigation. One of the things that you can do pre-trial is look at Millerell, and what happened between Batson and Millerell was, 18 years of arguing about what evidence we're going to look at to determine whether or not somebody has, an intentional bias. And the gist of it, coming out of it, is that you are going to take this sort of holistic approach and look at all kinds of evidence, and it's not limited to just a statistical, prima facie case, and it's not just the practices in that county. It's not that you can look at different kinds of evidence presented different ways. This is the bottom line. And so what we did in the wake of that in Quintero and a couple other cases was seek pre-trial Millerell hearings. So we took, and this is really resource intensive. You need, I think maybe some of Liz's students helped us. I know Jim Marcus, and we had a law firm that donated time. So it was a huge project, but we read, we were up against prosecutors that between them had 34 people on death row. And so we read all of the voir dire of those cases and pulled out sort of patterns, but we also looked at the statistics in the county and statistics of that office. Fortunately, this happened against the background of when Rosenthal, Harris County DA, was sort of self-immolating himself with these racist emails, and it was nice to have that as a background. And there were some emails divulged where district attorneys were talking to each other about the Canadians on their jury and how to get Canadians off the jury. So we had that as a good background, but that's just sort of anecdotal, sexy media hype, but it's not evidence. So we had we got set for a pre-trial Millerell hearing. We filed these motions that were, delivered on a hand truck, huge motions because they have volumes and volumes of voir dire, where we sort of showed the practices of those prosecutors and the statistical data of the office. We didn't have the smoking gun sort of manual like in Dallas County, but we had some former prosecutors, and particularly former African American prosecutors, and as well as some sort of old-time defense lawyers who were willing to testify. So we started gathering affidavits and began to subpoena them. And the judge granted our pre-trial Millerell hearing based on this huge motion and all the sort of data and the practices that we demonstrated of disparate questioning. So the African Americans are going to get questioned about their friends that are involved in the criminal justice system, the whites don't, you know, just on and on. She granted the hearing, and then as soon as we were subpoenaing and she saw the different people that we were subpoenaing, she suddenly flipped with no explanation and canceled the hearing. But the effect that it had to have that data was amazing. As we went through jury selection every day, at the end of the day, we would tally up whatever the numbers were and read those into the record. And then we'd come back the next day with some written objections to whatever the questions were, the pattern of questions. And so they were constantly having to sort of change their questions. It was really disconcerting at how, even when they're making up new questions in the face of this, they were very racially disparate. But we did that every day and really had them sort of off their game in what they normally would do. And they were very, nervous about striking African Americans. The very first juror number 1 was an African American from Louisiana, one of our new neighbors after Katrina. And he had a felony, and they thought, I'm sure, that they were going to be able to get him off because he had a felony, so they didn't strike him. And I pointed out, since I practiced in Louisiana, that you get a first offender automatic pardon. They didn't believe it. They thought that was crazy. So they left him on, figuring that and the judge said, okay, we'll research this law and come back after lunch. So when we called the clerk of his county to get the record of that felony, the clerk said to the person in my office, oh, and do you want the pardon? Because the last guy that called didn't want it. Which was the prosecutor's investigator. So, we come back after lunch and prove to them that, yes, first-time pardons are a thing in Louisiana. And that juror stayed, and that was just sort of the beginning of the end for those prosecutors. We ended up with really the most diverse jury that tried a capital case in Harris County. That we had, I think it was 3 African-American men and 4 Hispanic women, and only 2 white men. And from the Capital Jury Project that if you get more than 4 white men, you're basically going to get a death sentence almost automatically. So the goal is to keep it under there. I would say, though, just to counter that, that I don't think that selecting jurors based on race, the fact that we don't want our jurors whitewashed, doesn't mean that African American jurors are necessarily good for us. I think that in Miller L, Jim had folks going around interviewing